Welcome back to the show. An international court in The Hague has issued an arbitration result in a dispute over the South China Sea that involves China and the Philippines. China's Ministry of Foreign Affairs has issued a statement saying, quote, "The Ministry of Foreign Affairs of the People's Republic of China solemnly declares that the award is null and void and has no binding force. China neither accepts nor recognizes it." We continue now with our distinguished panel. Let's go to Yi Xian Ho in Hong Kong. Xian Ho, take us through some of the key facts in this dispute between China and the Philippines and the best way to resolve them.
The facts are very complicated, and for this reason, some scholars have already said many years ago that there are many possibilities to solve the issues, and this situation is not appropriate for legal settlement, for judicial or arbitral settlement, but ripe for negotiation. Basically, according to China, the issues are, issues of territorial sovereignty over some islands and reefs that are occupied by the Philippines, and also maritime delimitation between the two states. But then, according to the Philippines, it's basically two types of questions. One type is source, a maritime entitlement, and then the other type is activities that will follow from the first one. On the first one, according to the Philippines, the source of maritime entitlement would be the convention, or possibly also the dotted line. If the dotted line is somehow, it would be in tension, in conflict with the convention. And then, according to the other source is the islands and reefs in the South China Sea. In this respect, the most important question would be the qualification of these features as low tide elevation, rocks, or full islands. If low tide elevation, then the feature will have no entitlement. If a rock, then it will have only 12 miles of territorial sea. If a full island, then it will have the full-blown basket of rights as EEZ or continental shelf, etc., etc. But then China has never really negotiated with the Philippines on the submissions presented by the Philippines in such a micro way. China always, claim that the issues will be territorial sovereignty and also maritime delimitation.
Okay, as you say, it's a very complex case. Michael, if peace and stability is the goal here in the South China Sea, what can the United States do to facilitate that?
Well, I think the United States can do several things to facilitate it. I mean, first is to very clearly state its support for legal processes and the processes that have been laid out in the 2002 declaration by all the claimants about how to proceed in dealing with these disputes.
But the United States has got a problem here when it comes to looking at this in a very legal way, because a lot of this is based, of course, on a UN treaty, which is the UN Convention on the Law of the Sea. The United States has not ratified that.
Right.
So it weakens its position, doesn't it?
It does. It puts it in an awkward position. I mean, it still very strongly says it upholds the statutes of UNCLOS of the United Nations Convention. It regards it as common law, but it hasn't ratified. It's signed but not ratified the convention. And that really prevents it from having a seat at the table in talking about how UNCLOS should be interpreted and how it should be applied in various situations. But that doesn't prevent the United States from saying it believes the decisions of UNCLOS are in line with proper legal decisions, and that it will seek to abide by them.
And getting back to peace and stability, what does the U.S. do?
Well, I think the first thing is that, to support that. The second thing is, I think the United States really needs to itself initiate a more serious dialogue with the claimants themselves, and particularly with the Chinese. There's been far too much emphasis by all parties concerned on sort of military aspects of this issue. Freedom of navigation operations, exercises, patrolling of various types by both the United States and China. China hasn't conducted freedom of navigation, of course, but it's done other things with both its Coast Guard and with its Navy. This has really been at the forefront of a lot of the commentary in the press. This needs to be put on the side, and there needs to be an initiative made, hopefully with U.S. leadership, to get the countries to really start negotiating with each other based upon the 2002 declaration and the need to avoid any further provocations in the area. And I think the first step is the United States needs to talk to the Chinese and others about putting a cap on militarization of the area as a baseline for preventing further escalation of activities.
Right. Yi-Hai-Lin, is there a risk here that some countries could use this arbitration result as a pretext for provocative actions? I mean, what can China do to lower tensions in the South China Sea?
No, it's not the Chinese responsibility to lower tensions. It's all the players, all the partners' common responsibility to lower the tension. But I don't think 2 aircraft carriers deploying in the close water to China's South China Sea is kind of the attitude to lower the situation. So in that case, I don't think this question ask China is a good choice. Actually, this question should ask the United States, especially for ask the Pentagon why they send the aircraft carrier to South China Sea. What's the really intention? Is try to express some peaceful information? I don't think so. In that case, I think ask China to demilitarize the islands and in South China Sea is not a good answer and even not a good question.
There is another aspect to this. It's more for political international aspect, and that China has received the support of a number of countries, some of them ASEAN countries. There's a number of African nations. Russia has expressed support for the Chinese view. What kind of impact does this international support have on this case?
Actually, I think that means the arbitral tribunal didn't represent the whole international community. And firstly, I would like to re-emphasize, it's an arbitral tribunal. It's not an international court. It's not a court. It's only the tribunal. They are not judge. They are the arbitrator. So the so-called the final ruling is not a judgment made by the court. So it doesn't mean it can respect the whole international community, especially reflect the stance of the UN. And secondly, we should say, this not only for China's interest. There's a lot of the other countries also face a similar stance, so they share the common stance or the similar stance with China, such as India. Americans' navigation freedom is not only targeting on China, but also targeting a lot of the other countries. So that's why there's not only China and all the so-called China's friendly countries share the similar opinion. There's a lot of countries who face the similar problem, has the similar opinion.
Michael?
Well, I just wanted to clarify one thing. The Permanent Court of Arbitration under UNCLOS is the authoritative body for making decisions about the interpretation of UNCLOS to various activities to do with maritime issues. And its decisions under UNCLOS, it determines whether or not it has jurisdiction. It's the final authority whether or not you determine that factor. And B, when it makes a decision, that decision is not appealable. And C, it is binding on all of those who have ratified UNCLOS. It is an UNCLOS-based tribunal for the application of UNCLOS. So under that Permanent Court of Arbitration's decision, China and the other claimants are bound to observe its decisions.
Yi-Hai-Lin, do you want to respond to that?
Actually, we can also notice that if we carefully check the UN clause, you can find another items also can show that China and the other country has the right to pick what the solution method to solve their problem. Not only the arbitration the one way, and also the Philippines didn't fulfill their commitment during the DOC and the common agreements statements released by China and the Philippines in 2012. Actually, before the arbitration case, Philippines has the responsibility to launch the negotiation with China, but it has already been proved. Manila the government never tried this. So this is the point why China argued this. It's not a legal-based arbitration case.